Good morning, everyone. I hope everyone's having a good Wednesday and the weather is better for you guys than it is here in Columbia for us, if you are elsewhere. But thank you for coming to our webinar today on Wednesday, which is covering the homeowners associations and the law. My name is Zach Passmore, and I'm an enforcement attorney here with the South Carolina Department of Consumer Affairs. It's a pretty lengthy webinar today, so let's jump right into it and hopefully uh, we'll provide some useful information for you when it comes to the homeowners association laws. Quick preamble before I start talking. This presentation is not meant to serve as a substitute for reading the various laws discussed or requesting a legal opinion from the appropriate authority or seeking legal counsel. The department is providing this presentation merely for introductory and educational purposes and is meant to serve as an overview of the subject matter that I am discussing today. So today we will go through a few things. If you are not familiar with our department, I will provide a quick introduction for the South Carolina Department of Consumer Affairs and the various things that we do for consumers across the state. I will review the relevant South Carolina laws that cover homeowners associations. We will have a few examples and scenarios of how these laws work separate from each other and at times with each other. We'll also provide some tips on how to deal with HOA concerns, and I will overview certain department resources that are available to consumers and homeowners, such as our complaints process, our HOA report that we publish annually, and some educational materials that we have created. So if you're not familiar with us, we are the South Carolina Department of Consumer Affairs, and we were established in 1974 by the Consumer Protection Code, and we are the state's consumer protection agency. As such, we are the administrator and enforcer of the South Carolina Consumer Protection Code, as well as certain regulatory statutes that exist outside of the code. In this capacity, the department helps to formulate and modify consumer laws, policies, and regulations. We regulate the consumer credit marketplace. We resolve complaints arising out of the sale of consumer goods in South Carolina, and we promote a healthy, competitive business climate here in the state. Our department is governed by the Commission of Consumer Affairs, who appoints the administrator, Carrie Ruby-Barker, which is my boss, to manage the operation of the department. Our department is organized into 6 different divisions, including administration, our advocacy division, where we represent the consumer interest before state and federal regulatory agencies that set rates for things like public utilities and homeowners insurance. We have a consumer services division that runs our voluntary mediation of complaints. We have a public information and education division, which graciously helped set up this presentation today. And we have my division, the legal division, which engages in enforcement activities for about 15 licensed industries. So how can the Department of Consumer Affairs help South Carolina consumers? We are most known for our complaints process, where we provide voluntary mediation services for consumers if they have issues with certain businesses in the state. We will take the complaint from consumers and we will send it along to the business for a response, and hopefully that interaction will help bring forth a hopefully positive resolution for consumers to their issues. We also have a dedicated identity theft unit where consumers can report scams and report possible ID theft if they are a victim of ID theft, or if they think they might be a victim of ID theft. They can reach out to us and we can help consumers walk through the process of remedying ID theft. One useful thing that we can also provide are background services for a business. If consumers are doing research into whether or not they want to work with a certain business, I recommend that they check our online complaints database, where consumers can search our complaints database and get some general information about certain types of complaints that have been filed against businesses, how many complaints, a rough description of the type of complaint, and a general closing status of that complaint. That service helps consumers get some information on a business before they decide to engage with them. Our department also provides many educational resources, such as free presentations like the one we are giving today. And every Wednesday, we have a Wednesday webinar on various consumer topics throughout the year. And we're generally here just to answer any consumer-related questions that the public may have. Now, all of these services can be found on our website, www.consumer.sc.gov. And this slide is our homepage. And as you can see, you can easily find these services on the drop-down menu on the center of the homepage. So with that out of the way, we can get into the meat of the presentation today, and I will provide an overview on the South Carolina laws that may apply to homeowners associations. So how does an HOA know what they can and cannot do? There are essentially two buckets of information that govern what homeowners can and cannot do. The first one being applicable state laws. Here in South Carolina, there are three. There is the South Carolina Nonprofit Corporation Act, the South Carolina Homeowners Association Act, and for horizontal property regimes, the South Carolina Horizontal Property Act. All of these laws may or may not apply to your HOA in particular. Determining which one and which one's provisions do apply to your particular homeowners association depends on the construction of that HOA. The second bucket of information where homeowners or homeowner associations know what they can and cannot do is by virtue of the HOA's governing documents, which include things such as the HOA's declaration, the master deeds, and the bylaws, and the rules and regulations, which are frequently known as the covenants, conditions, and restrictions, or CC&Rs. HOA's declaration, master deeds, and bylaws cover the rights and responsibilities of members and the HOA, but mainly their purpose is to set out how the homeowners association will operate. This includes information on meetings, dues, special assessments, elections, and collection policies. Certain provisions in the rules and other governing documents may be superseded by state law. Generally, the rules and regulations, commonly referred to as CC&Rs, limit how a homeowner can improve or use their property. Topics often covered in the rules are related to landscaping, home and building standards, guests and pets, and things of that nature. One thing to note is that homeowner associations cannot include parameters that are in violation of local, state, or federal law, such as certain building codes within a county, and they can't permit something that the code prohibits. However, they can be more restrictive in certain situations, such as when it comes to the use of pools, roofing, and things of that nature. Now, the order that we are going to go through these applicable state laws in the first bucket are going to be from the most general construction to the least, we're going to go through these laws in the general order of least restrictive to HOAs to the most restrictive in HOAs. So the first one we're going to start with is the South Carolina Homeowners Association Act. This law requires governing documents to be filed and provides certain meeting notice requirements and access to budget and membership lists. The law also requires our department to collect specific data on homeowners association complaints and to report such data to the governor and the General Assembly. And before I start going into the specifics of this act, I do want to point out up front that there is often a lot of confusion as to this particular statute. Starting in the early 2000s, there were several HOA bills that were introduced in the legislature, and they took many different forms and included many different provisions. Some of them dealt solely with governing documents, while some of them dealt with preventing certain restrictions on homeowners' rights who lived within the HOA. The South Carolina Homeowners Association Act is the only one that passed, and that's the one that I'm going to cover today. It passed in 2018 and was amended heavily when going through the legislative process. The reason why I reference confusion is that it occurs because all of the previous iterations of the bills that floated through the legislature in the early 2000s, they can be found online. And oftentimes we will get questions from consumers referencing these bills. Those bills are not the enforced law. They did not pass the legislative process. The one that I'm going to discuss today, this is the one that has passed, and the others did not and are therefore not law and have not been implemented at this time. So with that explanation out of the way, let's get into the Homeowners Association Act. The Homeowners Association Act defines an HOA as an entity developed to manage and maintain a planned community or horizontal property regime for which there is a declaration requiring an owner to pay assessments for a share of real estate taxes, insurance premiums, maintenance or improvement of, or services or other expenses related to common elements and other real estate described in that declaration. One thing that is excluded from the South Carolina Homeowners Association Act are vacation time sharing plans that are organized and subject only to another provision in the Code of Laws. So the HOA Act applies to communities and horizontal property regimes requiring homeowners to pay assessments, and as I said, does not include timeshares. There is a filing requirement for these types of organizations for governing documents, rules, regulations, and amendments. One of the filing requirements are any governing documents, including HOA declarations, master deeds, and bylaws that existed before the act became effective, which was May 17th, 2018. These governing documents must have been recorded in the county where the association is located by January 10th, 2019 in order to remain enforceable. Now that part, recorded in the county where the association is located, depending on that county, there may be different places where these governing documents must be recorded. Depending on the county, it could be the clerk of court, it could be the register of means conveyance, or it could be a register of deeds. Depending on where the property is located, determines which office the governing documents will be recorded with. So any new or amended governing documents, rules, and regulations must also be filed in the county by January 10th each year following their adoption or amendment. An amendment is effective upon adoption or passage, but in order to remain enforceable, it needs to be filed by January 10th of the year following its adoption. Now, under the South Carolina Homeowners Association Act, homeowners do have access to certain documents, including access to the rules, regulations, and amendments. HOAs must make rules, regulations, and their amendments available to members upon request unless they are posted in a conspicuous place in a common area in the community, or they are available on a web page maintained by the HOA where a member can download them. HOAs can also email them to members. It's up to the HOAs themselves to decide how these required documents are to be made available. Another group of documents that homeowners shall have access to are budget and membership lists. All HOAs are subject to certain access to documents requirements in the South Carolina Non-Profit Corporation Act. That act I'm going to go into a little bit later, but HOAs are subject to these requirements for the purpose of letting homeowners inspect and copy the association's budget and membership lists. So if a homeowner is in a situation where they have requested these kind of documents and the HOA has not made them available, the enforcement mechanism for that homeowner, as provided by the Homeowners Association Act, is in court. That being said, you'd want to talk to a private attorney to consider your legal options, or you could file a complaint with our department and go through voluntary mediation, which I'll touch on a little bit later in this presentation. So under this act, there is a limited meeting notice requirement for budget increases. Associations other than nonprofit corporations must provide homeowners notice 48 hours in advance of a meeting in which the decision to raise the annual budget is made. This notice may be made through posting in a common area in the community or on the HOA's website or via email or by any other method described in the HOA's bylaws. It's important to note that this is the only situation that the Homeowners Act requires meeting notice, and that is the decision to raise the annual budget. It's also worth noting that this requirement applies only to associations other than the nonprofit corporations, because there are certain provisions of the Nonprofit Corporation Act that will apply to HOAs who have chosen to become nonprofit corporations. Under the Homeowners Association Act, there is a required disclosure for home buyers. The seller must let the purchaser know if the property is part of a homeowners association via the South Carolina Residential Property Disclosure Statement. You can find this disclosure on the link on the website that I have provided on this slide for the Labor Licensing and Regulations Department's website. So if someone is in a situation where they are considering buying a home, there are some certain steps that our department recommends they take when it comes to doing their research on the community's HOA. The first thing you would want to do is to get a copy of the governing documents of the HOA if you can, and request association meeting minutes from the past 12 months and any newsletters that were sent out during that time. Another thing prospective home buyers might consider is asking for something in writing from the HOA stating that the home is currently not in violation of any of the association's rules. If possible, a prospective home buyer might also consider attending an association meeting and talking to neighbors to see how well the association functions. They can also do internet searches for any online complaints or lawsuits related to the particular HOA. It's very important for prospective home buyers to do their due diligence to determine whether or not a property is involved in an HOA, because once you're in, and you're subject to the HOA's authority and are responsible to comply with their adopted rules and regulations. You may not have been there when they were adopted, but once you are in, you are bound by them. So under the South Carolina Homeowners Association Act, homeowners can take their monetary disputes to magistrate's court if the amount in issue does not exceed $7,500. There is currently a bill working its way through the legislature to increase that amount, but that is not, as of this presentation, the established law yet. The HOA Act also provides complaint processing and reporting from our department, the Department of Consumer Affairs. We are tasked to take and collect specific data on HOA complaints, compile this data, and share it with the Governor's Office and the General Assembly each year. So what role does the Department of Consumer Affairs play in the South Carolina Homeowners Association Act? Well, before the act, our department regularly received HOA complaints like we receive complaints against any other types of business. What the law changed was that now we have to take and collect HOA complaint data that is described in the act. HOA complaints have a specific supplemental form that includes the information we are to disclose, and if we do not receive that supplemental form, we are unable to process an HOA complaint. But once we receive these HOA complaints and the supplemental forms, we compile the data that we receive in these forms, and we share it annually with the governor and the General Assembly so that they can identify any trends in the HOA space and see if there's anything occurring that may require a law change. We are also here to provide education to homeowners and HOAs. Specifically under this act, what the Department of Consumer Affairs does not do is that we do not administer the HOA Act and we do not enforce the HOA Act. The Homeowners Act specifically says that our department does not have the authority to arbitrate any HOA complaints, and we cannot force a homeowner association to provide a particular resolution to a complaint or even to respond to the complaint. But in our experience, homeowners associations do respond to consumer complaints generally. And as I've stated previously, we have the voluntary mediation process that we provide. For this reason, we do encourage consumers and homeowners to file complaints at our website regarding their homeowners association concerns, just so we can be of assistance. So let's look at some scenarios that bring into account the Homeowners Association Act. So in this scenario, if the bylaws and covenants on file are older than 2018, are they still valid? The answer is yes, they are still valid if a governing document was recorded prior to the effective date of the Homeowners Association Law or Homeowners Association Act, which again was May 15th, 2018. If it was recorded prior to that date, then it is effective. Any amendments to that governing document must be filed by January 10th, the year following their adoption. In scenario 2, if the rules and regulations are amended, when can they be enforced and put into practice? Rules and regulations are effective when passed or adopted by whatever process the HOA has established. However, amendments to the rules and regulations must be filed by January 10th, the year following their adoption, wherever the county dictates they must be recorded in order to remain effective and enforceable. So that covers broadly the South Carolina Homeowners Association Act. As I said before, it is the least restrictive of the three Homeowners Association Acts. And now we're going to move up a level in terms of restrictiveness and discuss the South Carolina Nonprofit Corporation Act. So this act applies to HOAs that have filed its nonprofit articles of incorporation with the Secretary of State. One thing you may have noticed about the Homeowners Association Act that I discussed previously is that there is no filing requirement for an HOA to let any agency or department know that they exist. The only thing they have to do is file their governing documents with the appropriate entity in their county. However, if an HOA chooses to become a nonprofit corporation, they do have a filing requirement with the Secretary of State. They must file its articles of incorporation with the Secretary of State, and you can use the business filing search at the address that's on the slide here to search to see if a particular HOA is registered as a nonprofit corporation. There are very limited provisions of this Nonprofit Corporation Act that I'm going to discuss that also apply to homeowners associations that are not registered as nonprofits, and I will kind of highlight those instances in a few slides when we start working through some of the scenarios. This law provides details on meetings for the associations, including notice and quorum requirements, rules for the board of directors, and homeowners' access to records. So under the Nonprofit Corporation Act, a nonprofit corporation must have a board of directors or someone named in the articles who has the powers normally held by the board. A board must be made up of 3 or more people elected by members or appointed through the bylaws by whichever process that the bylaws have enacted, and their term must be for 5 years or less. Unless otherwise provided in the articles or bylaws, a corporation must have a president, a secretary, and a treasurer, and one officer must take minutes at directors and members' meetings. Under the Nonprofit Corporation Act, the articles or bylaws of the nonprofit corporation must set out how someone becomes a member of the corporation. Now, unless the act, articles, or bylaws say otherwise, each member is entitled to one vote. A quorum is 10% of votes entitled to be cast, and proxies are allowed. Now, it's important to note that depending on your particular HOA that's set up as a nonprofit, these rules can be different because, like the slide says, the articles and the bylaws could set up other requirements. Now, on the subject of access to documents, the South Carolina Nonprofit Corporation Act requires nonprofit corporations to keep certain items, including minutes of directors and members' meetings, including committees of the board, if there are any established. They must keep articles of any current amendments, names and addresses of the current directors and officers, as well as any written communications to members made within the past 3 years, including financial statements. Nonprofits must also keep records of all actions approved by members for the past 3 years and copies of any reports that they have filed with the Secretary of State. Members of the homeowners associations that are set up as nonprofits have the right to inspect and copy records that are held by the corporation. So when it comes to meetings, the types of meetings that can be held, and the notice and voting procedures under the Act, nonprofit corporations must have, at minimum, an annual meeting each year where the president and the chief financial officer report on activities and the financial condition of the corporation. In addition to this annual meeting, regular membership meetings and special meetings can be allowed. You would look to the governing documents of that particular HOA to determine which types of meetings are to be held. But under the Act, at a minimum, an annual meeting must be held. The meeting notice given to homeowners must be, under the statute, fair and reasonable. So if the nonprofit corporation notifies members in the following ways, the notice would be considered fair and reasonable. So under these requirements, meeting notice must have the place, date, and time of each annual, regular, and special meeting at least 10 days ahead of time, but no sooner than 60 days before the meeting. And the meeting notice must include any matter that members must approve if it's an annual or regular meeting, or if it is a specially called meeting, a description of what will be discussed. And the notice must include any issues a member intends to raise at the meeting, and if certain requirements are met, or if certain requirements are met. So let's take a look at how this act works in certain scenarios. In our present scenario, an HOA member is asking for access to meeting minutes from 5 years ago. Does the HOA have to provide them? If they are a nonprofit, then the answer is yes, because HOAs must comply with the Nonprofit Corporation Act in its entirety, and Section 1601 requires minutes to be kept in perpetuity, and Section 1602 requires records that these records be open for inspection upon written demand or notice from a member. Now remember, these types of permanent records that must be kept are meetings of all minutes of its members and board of directors, a record of all actions taken by the members or directors without a meeting, and a record of all actions taken by committees of the board of directors, if there are any committees. Now, what about if the if the HOA is not a nonprofit? In that case, the answer is maybe, and it would depend on what that particular HOA's bylaws say about record maintenance and retention. If you're in a scenario where for some reason the HOA does not comply with a valid request for records, then the Nonprofit Corporation Act allows the homeowner to go to circuit court for enforcement. Now, in another scenario, we have an HOA member that is asking for access to invoices. Does the HOA have to provide them? Again, if the HOA is a nonprofit corporation, then yes, they do. For similar reasons, the HOA must comply with the Nonprofit Corporation Act in its entirety. Section 1601 requires that appropriate accounting records be maintained by the HOA, and Section 1602 requires records be open for inspection upon written demand or notice of a member, including accounting records. Now, similarly to our last scenario, if the HOA is a nonprofit, then the answer is maybe, because it depends on what the HOA bylaws say about access to records. Now, one question that our department gets regularly is, what about attorney invoices? Are they subject to inspection and copying upon written request from a homeowner? And in this specific scenario, you can forget what I've said, because this is a complex issue. It involves many things, including such debatable things as to whether or not an attorney represents the HOA and therefore a member of the HOA, or if they represent the HOA exclusively. There's a seemingly valid argument that invoices showing payment to attorneys representing an HOA could be included as an accounting record. But there's also scenarios where, particularly hypothetically, a HOA may not want to disclose what certain activities that the lawyer is being retained for. And again, there are attorney-client privilege considerations to take into account. All that to say that it's a complex issue, and it's especially complex to answer since our department does not enforce the Nonprofit Corporation Act. So all that to say that is more of a question that you may need to seek the assistance of legal counsel to determine. So moving on, in scenario 3, we have a consumer who would like to contact a member of the board of the Homeowners Association. They ask the Homeowners Association for contact information for the board member. Can the Homeowners Association refuse to provide the board member's contact information? If they are a nonprofit, the answer is no, because the nonprofit corporation must comply with the Nonprofit Corporation Act in its entirety. Section 1602 requires records to be open for inspection upon written demand or notice from a member. And one of the types of documents that are required under the section include the list of names and businesses or home addresses of the current directors or officers, which is required to be kept under 1601. If it's a nonprofit, the answer is still no. That is because this is one of the scenarios where a certain provision of the Nonprofit Corporation Act extends past nonprofit corporations and can extend to homeowners associations that are not organized as a nonprofit. So this is because Section 273150 of the HOA Act does require all HOAs, nonprofit or not, to comply with certain provisions of the Nonprofit Corporation Act. So while 1601 does not reference it, or I apologize, while the HOA Act does not specifically reference 1601 of the Nonprofit Corporation Act, it does include Section 1602 and 1605, which includes a limitation on the use of the member list for the purposes of permitting access to the budget and homeowners membership list. Because of this, the HOA would at least have to permit access to the member list, which would likely have the board members' information on it that this homeowner is seeking. So that covers the South Carolina Nonprofit Corporation Act. So now we'll move on to the most restrictive or most descriptive of the Homeowners Association Acts, and that is the South Carolina Horizontal Property Act. Horizontal property regimes are usually set up in apartment complexes or condominiums. The law governing these regimes is even more specific than the Nonprofit Corporation Act and the Homeowners Association Act that I've already covered. Under this act, when it comes to setting up a horizontal property regime, there is a filing requirement. So lessees or owners must draft a master deed or lease stating that they want to create the regime. They must attach bylaws, plot plan, and building plan. And they must record it with the Register of Deeds or Clerk of Court in the county where the property is located. This master deed or lease that they attach must include several things, such as a description of land and buildings, a general description and the number of each apartment, a description of common elements and restricted common elements, the value of the property in each apartment, along with the percentage of rights to common elements. It must include the name of the regime, followed by the words horizontal property regime. And it must provide a description of legal rights and obligations of an apartment owner, the co-owners, and the person establishing the regime. And if this is a situation where a property is being developed in multiple stages, there are additional items in the Horizontal Property Act that must be required in the master deed or lease. When it comes to the bylaws, the horizontal property regimes must include sections on the administration of the regime, whether it will be run by an administrator, a board, or some other entity, and the powers, manner of removal, and the compensation for these persons. It must include bylaws on the method of calling a meeting for the owners, who will preside over such meetings and who will take minutes. And the bylaws must include a section on voting, and that a majority of at least 51% is required to adopt decisions. So, as you might see when we're discussing the various acts, this one differs from the previous acts that I've discussed because it goes so far as to require the certain things that must be included in a regime's bylaws. Largely under the other two acts, they stay silent on what must be included in the bylaws. Some other things that must be included in the bylaws of horizontal property regimes are a list of the common elements and services, a description of the care, upkeep, and surveillance of property and common expenses, and the designation and dismissal of personnel necessary to provide common services. And there must also be a section on payments, that's a description of the manner that payments will be collected from owners. So when it comes to expenses of the regime, owners must contribute a pro rata share toward expenses of the administration, the maintenance and repair of common elements, and the repair of limited common elements, such as things that insurance doesn't cover, for elements that are shared by a few of the owners, and any other item or service that is agreed to in the bylaws. Assessments left unpaid at the time of an apartment sales will be taken out of the sale price. The regime administrator must keep detailed records of receipts and expenditures, and owners have a right to inspect these books and vouchers in a manner that is prescribed by the Horizontal Property Act. And if you have a question about what the pro rata share of expenses is, that is laid out in the Act on how that is determined. So under the Horizontal Property Act, each apartment owner has certain rights, including the right to exclusive ownership of their apartment and the use of common elements, so long as their use does not hinder the rights of any of the other owners. When it comes to common elements, these things are defined, and they include things such as elevators, garbage incinerators, basements, flat roofs that owners may have access to, the yard, gardens, any main walls, roofs, hallways, lobbies, stairways, etc. And any limited common elements are those common elements the owners agree are reserved for the use of specific owners. The Act also includes other provisions for things such as repairs, insuring the property, and how to dismantle the regime if needed. So let's look at a scenario where the Horizontal Property Act comes into play. I live in a horizontal property regime. Is it true that when the unit above me has a water leak that damages my unit, I am responsible to fix via my insurance? And at this point, I give you the standard lawyer answer that it depends. And it depends on several things. It depends on the master deed and the lease, and how the full rights and obligations of an apartment owner or co-owners are described and set. It also depends on what the definition of the general common elements are in the master deed, because it can include any number of things, as I've said earlier, such as main walls, roofs, compartments, installation of central services, such as power, light, gas, cold, and hot water, refrigeration, et cetera, et cetera. So as you can see, it depends on many things, and it also could depend on things such as whether the leak occurs in your personal area or in common areas, the common elements. Another question could be, what's the cause? If it's caused by some essential service being provided to the property as a whole, or if it's caused by a particular person that lives in the regime. The way that a regime works is that both owners of the properties insure the property through the regime, but they also carry their own homeowners insurance. So it really depends on the specific circumstances of the damage and what the master deeds or lease says regarding the owner's responsibilities and co-rights. Since the law requires that processes be created for the insuring of general common elements, it could be possible that insurance will be paid out through the regime. So, as you can probably surmise, the answer to this depends on just so many different elements that are specific to an individual horizontal property regime. So that is a large or generally broad overview of the 3 HOA acts that we have in this state. So now I will switch to some tips for dealing with homeowners association issues. Again, it's important to remember that there is no state agency in South Carolina that administers and enforces these laws that we've talked about. So with that being said, what can a homeowner do? Well, the first thing you want to do is to be prepared. You want to look to your rules and regulations and your CC&Rs or any governing documents that establish the HOA, and you want to see what it says about the particular issue that you're dealing with. And you want to check your governing documents to see if a formal dispute process has been established in your HOA. Once you've done that, you might consider trying to talk with your HOA board of directors and seeing if raising the issue can move forward to resolution. If you are not happy with your results from that, you may consider electing members that you think may be more responsive to your needs, or you may even elect to run for yourself. If the issue involves a monetary dispute, magistrate's court may be an option. Of course, you can also seek the legal advice from a lawyer that is well-versed in HOA matters. And if you need help finding such an attorney, the South Carolina Bar Association's lawyer referral service can help with finding attorneys that agree to take consultations. You can visit their website at lrsicbar.org or by calling the number on the slide here. Lastly, you may consider filing a complaint with the South Carolina Department of Consumer Affairs. As I've stated earlier, we have a voluntary mediation process where we send the complaints to the HOAs and we engage them in mediation, and hopefully our involvement can help the parties resolve the issue that's being complained about. Another thing that you may want to consider is to contact your legislators. Now on this slide, I have a screenshot of scstatehouse.gov. That is the website that is the portal for the South Carolina legislature. If you need help finding your legislators, you can look down at the section that I've identified on the left, the lower left. You can put in your address and get a list of your legislators, and you can contact them voicing your concerns for any or any argument for a change in the laws. If you look to the right-hand side of the website that I have highlighted, you can also run a search for any proposed legislation that is going through the legislative process. You can search by keyword. As you can see on the slide here, we've got Homeowners Association in the search box, and it will pull up any bills for this legislative session and past legislative sessions that involve homeowners associations. Now on this slide, I do have a list of some pending legislation regarding homeowners associations that are kind of working their way through the legislative process. While I do list them here, it's important to remember that these are bills only, and as of the time of that I'm giving this presentation, or the recording of this presentation, if it is put up on our YouTube page later, it's important to remember that these are bills and have not been adopted as law by the legislature, and therefore have no legal enforceability or authority. That being said, there are some bills that are going through the House of Representatives right now, including House Bill 3350, which would amend the HOA Act to define internal dispute resolution process. It would expand the applicability of the Nonprofit Corporation Act to records requests and voting provisions, and would establish exclusive magistrate's court jurisdiction. So, as I said earlier, magistrate's court has jurisdiction over monetary disputes under $7,500. This bill would establish exclusive magistrate court jurisdiction regardless of the amount. House Bill 3447 would require that HOAs rule to show cause before any foreclosure action. House Bill 3425 would establish certain financial disclosure requirements, prohibit HOAs from paying utility bills on behalf of an owner, and it would require notice to homeowners and a quorum for meetings before spending funds that are not provided for in the budget. House Bill 4006 would create open board meetings and has certain provisions for political sign placement and state flag allowances, and prohibition of certain parking fines. Now, over on the Senate side, there are three bills working their way through the process right now, including Senate Bill 68, which would allow HOAs to adopt and enforce certain rules related to the display of political signs. Senate Bill 131 would require HOAs to file income tax returns. And Senate Bill 366 would increase the Nonprofit Corporations Act's inspection and copyrights for HOAs that are not nonprofits. It would also prohibit foreclosure authority for HOAs and allow liens on property for unpaid dues. As I said, none of these are law yet. They may or may not become law. It all depends on how they work their way through the legislative process. Now, as far as our department, there are certain resources that we have to help homeowners with their HOA concerns. Again, if you want to go to our website, you can file a complaint on the drop-down menu. And on the next page, you will see that there is a section for filing a homeowners association complaint. There are two ways that you can do this. The one that we would recommend would be through the online complaint portal, but you can also submit a paper complaint form. It is important, though, however, if you are filing a complaint against an HOA, that you provide the HOA supplemental questionnaire. This is a required document, and we would not be able to move forward with our process if the supplemental questionnaire is not provided. We also have some resources for homeowners under our Consumer Resources tab on our website in a dedicated Homeowners Association education link. And on that page, we have the full text of the 3 laws that I've discussed today, if you want to look at them yourself. We also have copies of all of the HOA reports that we have submitted to the governor and the General Assembly, including executive summaries and the current report. We also have contact information for relevant departments that may be able to assist with your HOA concerns, including the South Carolina Bar if you are needing assistance finding a lawyer to help you. We have also prepared summaries of the acts that you can take a look at that covers a lot of the information that I have discussed today, as well as some frequently asked questions that the department receives regarding HOAs. Our department also has a YouTube channel, in addition to covering all sorts of consumer issues. And I would invite you to go to our YouTube channel and take a look at our offerings there for all sorts of consumer issues. But we do have a dedicated playlist for homeowners associations issues that will include things such as this presentation, our HOA 5-year complaint report, and other reports moving forward. So that being said, I will open the floor up to some questions if you want to punch them into our question box. I do have, while you are entering questions, I do have some questions that have been submitted prior to this webinar that I will address right now while you guys are getting your questions into the question box. So the first one we have is, other than mediating a complaint, what action can South Carolina Department of Consumer Affairs do to resolve HOA issues? Well, as I said before, the department does not have regulatory authority over HOAs or enforcement authority over the various HOA laws. That is explicit in the HOA laws. Our role is to report HOA matters to the legislature and provide general education information about HOA laws. As I've said a couple times, we do attempt to assist homeowners with their HOA issues through our voluntary mediation process, and we encourage homeowners to file complaints with the department, both to avail themselves of the mediation services that we offer, but also so that we can provide accurate information to the governor and the General Assembly regarding HOA matters. Another question that we received is, what can homeowners do if an HOA raises fees more than what is allowed by governing documents? Homeowners can utilize the methods I described earlier, such as voicing their concerns at their board meetings. They can organize homeowners to challenge decisions by the board that they may disagree with. They can vote for members that are more receptive to their concerns, or they can run for the board themselves. Furthermore, they can speak to a private attorney, consider any legal options that may be available to them. Another question that we received in advance was, can a board legally take money from reserves to pay annual insurance in full, knowing the association is in need of other repairs? The actions of the board, or the actions that the board may take, depends on the governing documents of the HOA or the horizontal property regime, depending on how they're set up, and the powers that are granted to its officers. So in those situations, you want to look to the governing documents to see what powers they have. Can a nonprofit HOA increase membership dues without approval from the members if the articles of incorporation have no provisions about membership dues? Well, answering this question in a general sense, as it's worded, no. However, any application of the laws to specific issues would need to be adjudicated by a judge. And since I'm not a judge, I can't answer to a specific instance. But just from our experience here at the department, it is unlikely that an HOA's governing documents would not address the collection of dues. Okay, another question that I received was, can a nonprofit HOA require that some members have 2 votes while other members only have 1 vote? If the HOA has not established any classes of membership. Now, if that's the case, and again, I'm answering broadly as possible, I cannot answer to any specific instances with any particular HOA. But if an HOA truly has not established any separate classes, then the Nonprofit Corporation Act would control. But that being said, it's important to keep in mind that the term voting member or the term membership class can be defined in the governing documents by another term, or may result as an operation of how the bylaws themselves are written. They may not necessarily be described as a voting member or a membership class. So it's important to carefully review the governing documents of that HOA to see how they are defined or if any alternate terms are used. A related question that we got to that point was, can an HOA amend its bylaws to prohibit some members from voting without establishing classes of membership? Again, it's similar to the other situation where if it's truly not been established, then the Nonprofit Corporation Act would control, bearing in mind that it may be defined in another way. So it's important to look at your governing documents to see how they're defined. Another question we received was, can a nonprofit HOA amend its bylaws to prohibit the majority of its members from running for election to the board? The Nonprofit Corporation Act does not specifically establish any candidate requirements. Therefore, an HOA may do so in accordance with whatever process it has established within its governing documents. And to that point, we also got a question saying, can an HOA amend its bylaws to prevent any member from running for election if that member is fully able to serve? Again, Nonprofit Corporation Act does not specifically establish any requirements for candidacy. Therefore, you have to look to the bylaws and any amendments. And finally, the last question we got in advance was, if street parking is legal and my neighborhood is not in a gated community, but the covenants say that street parking is not permitted if it is a habitual or long-term situation, is the HOA allowed to enforce the covenant? Well, if local laws do not prohibit the rule itself and the covenants are properly enacted and recorded in the way that they're supposed to be, and also were adopted by the HOA by whatever process that is necessary, then an HOA may have an ability to enforce it. But again, that is kind of a question that could hinge on the specifics of your HOA itself, the community or the municipality that you're living in. So if you were wanting to apply that to any specific instance, I would recommend talking to a private attorney to kind of walk you through it. Okay, looks like we have a good bit of questions here. So let's see if I can go through them. So the first question we got, do laws under Title 33, corporations, partnerships, and associations apply to HOAs? Well, again, it depends on how they're set up. If they are a nonprofit, the South Carolina Nonprofit Corporation Act would apply. So if obviously Title 33 would apply to nonprofits that are set up that way. And as I explained earlier, there are certain scenarios where Nonprofit Corporation Act laws would apply to HOAs that are not established as nonprofits. The next question that I received, how do rules and regulations differ from governing documents? Rules and regs kind of cover the things that homeowners are responsible for, or rules that apply to homeowners, and governing docs apply to the administration and the establishment of the HOA. Must an HOA provide a copy of rules and regs to membership without requiring members to go in person? and pay to view and copy the rules and regulations. Well, again, it depends on how the HOA is set up. But when it comes to rules and regs, I believe they can set up the method of how they provide them to members. And there are certain ways that they can do that, either through registered mail or email or posting them in a common place. Next question I got: what happens if an HOA doesn't file their amendments on time by January 10th of the following year? What if they're late? For how long is the rule no longer enforceable? Well, as I said, under the HOA Act, they must be recorded by January 10th of the following year in order to remain enforceable. So they can go into effect prior to January 10th, but in order to remain in effect, they must be recorded wherever they must be recorded. Okay, next question I got: will this material be emailed to participants for later review? I'm sure we can make it available. Bailey, our public information assistant, she may have dropped this presentation into a link already. I'm not exactly sure, but we can make these materials available.
Zach, if you're able to drop it into the chat, it won't let me do it because you're the host, but I did send it to you separately. It might let you send it to everybody so they can download it.
Did you send it to me?
It said I sent it. Yeah, it said I sent it to your direct message in the chat. Hopefully it showed up. Because it wouldn't let me do it for everybody.
Yes, I see it.
Okay, cool.
Let me see if I can drop it in. Sorry for the technical difficulties, everyone. Let me see if I can drop it into our into the question here.
Well, I may just have to email it out because looking at
I have to email it. Forgive me, everyone. No, it doesn't look like it attached. This is my first time using Zoom for a webinar, so it doesn't look like it actually sent the file. So yeah, we can get that distributed out through email. But thanks for raising that for everyone. Okay, back to the questions. Regarding notice of meetings, where the beginning of the presentation referred to 48 hours notice required for meetings to increase the budget, is this the only requirement for notice of meetings of board of directors? Under the Homeowners Association Act, that's the only requirement. For notice would be in instances where the meeting's purpose is to increase the budget. Other meetings can be called, and I would suggest you take a look at the HOA's governing documents to determine the notice requirements for that. What happens if none of the members want to be board members and the majority of residents demand to dissolve the HOA? That is a tricky question, and I would suggest talking to a private attorney to address that question. Regarding HOA members lists and contact information, can that include email and phone numbers, contact information, or is it limited to only addresses? I apologize. I don't know off the top of my head. I believe the act only specifies home and or business addresses. So if you do look at the Nonprofit Corporation Act, it will be there. I just apologize. I don't know off the top of my head. Is that available upon request with the management agent? That information would be in your governing documents or your bylaws to see where requests for these documents need to be made. Okay, we have a question using the scenario for the water leak that I used earlier. Do members have the right to access the HOA insurance policies in their entirety without having to pay to go in person to review those documents and also pay to copy them? That depends on several things, such as if we're talking specifically about horizontal property regimes, that would depend on the bylaws. So those sort of issues would be in the bylaws of the regime. Okay, we have a question regarding vote tallies, and would a request for vote tallies during an annual meeting be included for information requests? Is there a time limit on this type of request? I don't believe the Nonprofit Corporation Act includes vote tallies as one of the required records that must be available to homeowners. But again, look to the bylaws and governing documents to your HOA to see what kind of documents that may be available in addition to the ones that are outlined in the Act. Okay, another question we got: if a required annual meeting doesn't take place because of a lack of quorum or is canceled and budget isn't approved as required by the association, does the board need to continue trying to have an annual meeting and forgetting the budget approved? Well, that again depends on the governing documents of the HOA itself. Under the HOA Act, the only requirement is for an annual meeting. I'm sorry, under the Nonprofit Corporation Act, annual meeting is required. So look to your governing documents, as you all might be noticing that is the answer to a lot of these questions, as you have to look to the particular HOA's governing documents to understand the processes that are required for things like meetings and voting and things of that nature. How do you file complaints against management companies providing services to HOAs if such management agent is also a real estate company? You can file that complaint here with our department, and I believe in this scenario we would handle the complaint. However, if there is another agency with overlapping jurisdiction, if we determine it needs to be sent along to that other agency, we can surely do that as well. Another question we got: is there a difference between a homeowners association and a property owners association? I do not believe so. I think the terms are fairly interchangeable. It's just depending on the governing documents of that particular association. Another question we got is: where can one find more information about short-term rentals? Oh gosh, off the top of my head, I'm not sure. I know there is an act that covers timeshares and hotels and things of that nature. I apologize, I don't know them off the top of my head, but those would be the places that I suggest. Another question we got: what if your association is registered as a mutual benefit corporation instead of a nonprofit? That may be outside the scope of today's presentations. Obviously, if it's a nonprofit, the Nonprofit Corporation Act applies. If it's a not nonprofit homeowners association, then the HOA Act applies, and in certain scenarios, the Nonprofit Corporation Act applies. And if it's a horizontal property regime, then the Horizontal Property Act applies. Are HOAs required to provide bank statements? That is a question that you may need to go to a private attorney to consider. I know under the Nonprofit Corporation Act, certain financial documents must be made available. I don't know if bank statements would fall under that umbrella. They might, they may not. So I would recommend talking to a private attorney on that one. Another question we got is, what can the HOA do if they don't have the money to maintain the property properly? In that scenario, you have to look to the governing documents of the HOA to see what powers they have and what officers of the HOA have. Okay, we have a question regarding selective enforcement of rules of an HOA organization, whether or not that would negate the HOA. I cannot answer that question definitively. That's a question for a private attorney. All I can say is look to the governing documents and the bylaws of that particular HOA and utilize the process that I've talked about earlier to try and get change through your HOA, be it, getting homeowners together to a common cause, or voting in new people, or running yourself, or addressing, your concerns with the board. Okay, another question we have: can an association have two different monetary dues for the same class of membership? That would be something that would be outlined in the governing documents of that particular HOA. Okay, next question we got: can the board make decisions regarding common areas of the property without an association vote? The common areas being owned by all owners, using the example of easements. Again, that's another thing that depends on the bylaws and the governing documents of the particular HOA. So you may have to review those documents and voice your concerns at the next meeting, potentially. Another question that we received is, what document is a nonprofit HOA guides and directs the use of reserve funds when an HOA governing document just does not state the use of them? Where can I find this? I'm not sure off the top of my head where you might be able to find that. I don't think that something like that is a filing that's required with the Secretary of State. My best recommendation there would be to talk to a private attorney to try and sort out a records request, or whether or not there are any legal remedies or legal avenues for obtaining such information. Another question we got: can a board president knock on someone's door and enforce a rule he just wrote that morning? That sounds like a pretty unusual circumstance, but broadly speaking, HOAs set their own methods for enacting rules, and the HOAs must go by their processes that they have established in enacting those rules. Okay, yeah, we have a question kind of reiterating what I was saying earlier about the types of contact information. And they say only addresses are required to be provided. I believe that's correct. Although, like I said previously, look to the particular HOA's bylaws to see to see if any other information would be included. Regarding amendments, can they be changed in the absence of a meeting? It depends on the HOA. Like I said before, the if it's an HOA that's not a nonprofit, the only notice for meetings that must be provided to homeowners is for budget increases. For nonprofit corporations, it would depend on the bylaws that are established for that particular corporation. Okay, so we have a question. A neighborhood with covenants without an HOA established at the time of development in the 80s. There are questions between neighbors and real estate agents about whether or not they are still viable. If they are, complaints made to your office. My first suggestion would be to talk to a private attorney regarding that, just because without going in any specifics, there are so many variables at play there as to what the situation is regarding such an arrangement. Another question we got: if an annual meeting is required and doesn't take place, what happens? What are the consequences to an HOA? That is determined by their governing documents, and also if a particular homeowner or a group of homeowners is aggrieved by such an occurrence, I would suggest they talk to a private attorney to consider their legal options. This last question here regarding an HOA community with several sections and a golf course within the overall community. That is not something that I can get into on this presentation. I can only speak to general application of the rules. If you would like to reach out to our department and maybe file a complaint regarding your specific HOA, we can certainly take a look at that. Okay, the last question that I have is, oh no, I'm sorry, I do have another one that just popped up, but the next question I have then, I mentioned that property values and ownership percentages must be in the master deed. Must the ownership percentages be based on the property values? That is determined by I'm assuming you're talking about a horizontal property regime there. The percentages would be outlined in the bylaws of that particular regime. Okay, that actually does look like that's the last question that I've received. There was a comment regarding a HOA and certain issues that a consumer may have with them. To you, I would suggest filing a complaint with our department so that we can maybe help, like I said, through our voluntary mediation processes, or having the data for the governor's office and the General Assembly for our HOA report. So that looks like all the questions that I have received. Oh, well, I did just get one more. What are the laws regarding having to pay fees to review documents and when those documents are required under the Nonprofit Act? I don't think the Nonprofit Act goes into detail regarding any fees. I know that it requires these certain buckets of documents must be made open for inspection. So presumably an association could charge for copying the documents. All that to say that probably look to your association's bylaws to see anything regarding any fees that may be required for inspection or copying of these documents. Can an HOA be governed by both horizontal and nonprofit corporation act? So just kind of, again, at a broad sense, the horizontal property act is more descriptive as to what is required, but the nonprofit corporation act can apply to horizontal property regimes in certain instances, such as the certain inspection of documents that I discussed earlier. So that looks like all of the questions today. I hope that was helpful, but you can always email your questions into our department and we can try and answer them as best we can. So let's move on a little bit now to the end of our presentation. This is the kickoff to National Consumer Protection Week. As a part of National Consumer Protection Week, we're actually celebrating the entire month as National Consumer Protection Month. But the department has several events planned in conjunction with this, including Wednesday webinars. Every Wednesday this month at 10:30, we will have webinars on the topics that are on the slide here. So next Wednesday will be My Information Was Breached. Now what? Oh, I apologize. They're not all at 10:30. Moving forward, I apologize for that. They're typically 10:30 when we're not in National Consumer Protection Week. But next week's webinar will be at 10 o'clock, and the subject will be My Information Was Breached. Now what? On March 19th at 2:30, we have Identity Theft and Scams and How to Stay Safe. And on March 26th at 2:30, we have Artificial Intelligence Scams. We also have some shred days going on around the state. I believe we just had one last week in Columbia, but we do have some more fanning out across the state. Tomorrow we have one in Greenville at the Herring Center at Furman University from 11 to 2. And on Tuesday, March 11th, we'll be in Myrtle Beach at the same time from 11 to 2. So if you're in that area, bring your documents, your financial documents and sensitive things that you want shredded. And on Thursday, March 27th, we will be in North Charleston at the North Charleston Coliseum. I also invite you to connect with our department across our social media. We have a presence on Facebook and X or Twitter. And we also have the YouTube channel that I mentioned previously with presentations on various consumer topics. We also have a lot of printed materials available on all sorts of consumer issues that you can access in PDF form on our website, or you can contact us and get hard copies if necessary. And that is the end of today's presentation. I hope I know I threw a lot of information at you, but I hope it was useful. And like I said, if you have any particular concerns with your HOA, we would encourage you to file a complaint with our department to see if we can assist through our mediation processes. And with that, I wish you guys a good rest of your day and hope you enjoy the rest of your week. Thank you.